We proceed.
Much obliged, Honorable Chairman and members. Serial number 1 is Uganda versus retired Colonel Chiza Besigye. It's coming up for mention.
I don't know if the seats are not enough, then you can use the other line can extend behind, and then they have seats also near. I think defense now you can proceed. If it may please you, Mr. Chairman and honorable members, I'd just like to go on record about representation of the accused persons by first of all introducing myself, Rwagerias, as one of the lawyers. Mr. Chairman, we intend to address you on issues regarding the lead counsel, who is Honorable Martha Karua Wangari. She is a practicing advocate within the Republic of Kenya. And Mr. Chairman, she has got her certificate of practice, and she's in the process of securing temporary practice to be able to handle this case as the lead counsel. She takes charge of the entire legal team here and internationally. Other members, Mr. Chairman, for the record, Mr. Chairman, if I may pass on her documents to the judge advocate here. Mr. Chairman, we have my land friend. No, for the record, the Honorable Martha Karua is a senior advocate. She's a senior counsel. She has that title. We have my land friend Ernest Kalibala, who has been before this court since morning. We have Counsel Aaron Chiza, who is here. Narukora Eliasa Luyimbazi, Ronald Samuel Wanda, Chintu Michael, Katoto Musime, is Kakuru Tumusime around, Sekanja Kabubakar, George William Mukula, Sekade Julius, Kunihira Proscovia, by Diane Tulinawe, Mugagga Mukuve Karemire, Katushabe Ronald, Isaac Kwagala, Faruku Kamreke, is Kabuye Lawrence Round, Kato Wilson, John Mata Nsimbi, Cyrus Ogul, Tugume Moses, Akakimpa Godfrey, Muizi Samuel Mulindwa, Kijambu Gordon Mukisa, Tenderi Rafael, retired Major Roland Iduli, and Enap Dennis Adim. I don't know whether there is anyone I've not introduced. So far, that is the team, Mr. Chairman and honorable members. But for the record, Mr. Chairman, Senior Counsel Martha Karua is still coordinating a team of lawyers from Kenya, from Nigeria, from Tanzania, Pan-African lawyers, to be able to take charge of this honorable case. Rather, this case as our lead counsel. The unfortunate bit, Mr. Chairman and honorable members, since she arrived in the country yesterday, she has not had any opportunity as the lead counsel to interact with the accused persons, save for the instructions that were given formally. But as for any conversation about the matter, effective instructions and discussions, we are yet to finalize that. Secondly, this morning, Mr. Chairman and honorable members, we visited the office of the law counsel, and we had the opportunity of talking to the chairperson of the council, Justice Irene Mulyagonja, regarding the process of securing a temporary practicing certificate as required under Section 18 of the Advocates Act. Unfortunately, she informed us that council is yet to sit and pronounce themselves on the matter. And as we talk right now, they are yet to finalize the process. The assurance she gave us is that they are going to expedite the process and that we may hear from her probably tomorrow or the day after. So that is the assurance we are given. The long and short of it is that, Mr. Chairman, the right to a fair hearing entails effective representation under Article 28 and the relevant authorities we have here. So we have to have the team fully constituted and also instructions effectively given to the lead counsel on how to manage the team. In other words, she's our team captain. We should be seized with all the tools and facilities to be able to take charge of the matter. And this is where we stand today, and this is critical in the dispensation of justice, Mr. Chairman and honorable members. Wanted to bring that to the attention of this honorable court. With your permission, Mr. Chairman, I would like my colleague to pick it up from there, Ernest Karibala, if you may. Most obliged, Mr. Chairman.
May it please court chairman and other court members, before we proceed to have a ruling of this court.
Excuse me, we are still proceeding. If it please you, let us first finish our submission.
Please sit down.
Thank you very much.
Sit down.
We are still proceeding as defense counsel. We shall not allow you to proceed. Listen, as we are proceeding as a defense team, we have not finished.
Okay, let them finish their part, then you will reply.
No. So the council has no locus. This is what I'm going to talk about.
No. I have all the locals. Even
No, I
in
mean the one that is
justice. What are you talking about?
We are not for a fight.
So, Mr. Chairman,
It's their turn. You leave them, let the defense lawyers put up their...
Mr. Chairman, the prayer we are making, if we could be given time to interact with their chosen persons, considering the prevailing circumstances where we have the lead counsel who has that issue, who is incapacitated as of now. So it's not a matter for debate, Mr. Chairman, or for argument and counter-arguments.
Council.
I mean, Chairman and members of this honorable court, if I may put this point succinctly, is that the defense team requests this honorable court to talk to the clients, Besigye and Millitary, and then we get effective instructions on how to proceed, because this is not going to be business as usual. Thank you very much.
I wish, counsel, you could reduce on your tune. That one has no problem. Council Road Mayor, what time do you want to talk to him now, or you want to talk to him any other day?
No, we want to talk to him right now, but in the camera, not in public here.
Yes, we can also allow that if it is not going maybe to take a long time.
Like 30 minutes? Honorable Chair, I was very clear. The instructions given are to the effect that Honorable Martha Karua takes charge as the lead counsel. And there are some legal hurdles we have encountered along the way. It is his decision to take any other decision if he so wishes. So this is the matter. This is the issue we are raising. That if there is any adjustment to the instructions, we need to confer with him or with them. So the question is, all along we have been seated outside, we have not had any opportunity of interacting with him. So right now, that's basically what we are seeking for. Like 30 minutes, we agree. We decide on the way forward, we chart the way forward after having a conversation with him over these issues. I am sure he's just getting information about what we have been doing at the law council just right now here. We had not yet even briefed him as to the progress of the matter before the law council. And these are the issues we should be discussing with him.
And for the avoidance of doubt, that's why Honorable Martha is not yet speaking. We want to talk to the two clients so that they allow us, in the meantime for today, to proceed without Honorable Martha leading the team formally, because they may ask themselves that we chose Honorable Martha to lead and we see Rukwago and Karibara. No, so we are trying to consult them to make them appreciate. So for now, Rukwago and Ernest are leading, as you have seen, and they are requesting, the team is requesting to confer with the client for 30 minutes in the camera so that we can effectively represent them. Yes, thank you very much.
You can hear from state, because you want...
State 2 of Uganda People's Defense Forces procedures. That is paragraph 3. And those ones who have comprised Rukwago, Chiza, Narukora, and Masiko. So I think the rest should not be on record. Yes, they have not complied. Read the regulation. Unless they comply with this regulation, they should not be on the record. Person is entitled to appear as advocates.
Order, please.
So I will simply go to paragraph 3. If an accused is to be defended at his court-martial by an advocate not nominated by the convening authority, the accused shall give the convening authority notice of his fact not less than 24 hours before his trial. So it is only those who have complied with that. Even the document, this document here, which is before court, it is as if it is coming from this court. It is a Republic of Uganda, Uganda People's Defense Forces in the General Court Martial, holding at Machine. So this document does not bear the address. I don't know even if the person who signed it. I don't know the person. So these people are not properly before this order of court.
I think, Councillor Pago, this goes back to what you pray for an adjournment, and you clearly put everything right.
The prosecution is misleading this court. The instrument is reading was about law firms. It's not about the particulars of the individual advocates. Actually, where I was reading, my name is not there. It's Lukwago and Company Advocates. If we cared enough to look at the list I was reading, he would see the individual advocates and the law firm they come from. They are indicated there. So this is the list. So there's a difference between law firms and individual practicing advocates. For example, Martha Karua on this list is care of Lukwago and Company Advocates. And it is in black and white. So I don't know, his point is neither here nor there. To me, Mr. Chairman, it be considered as a very serious matter. And in any case, the lawyers are here. If you want their particulars, we can furnish them to court. They are here. So those are the things the Constitution intended to cure. Article 126. Maybe it's not applicable in this court. But if the Constitution is the fundamental law of the land here, it's very clear. Substantive justice as opposed to those minor technicalities, which are neither here nor there. So I don't think we should indulge in those gymnastics, Mr. Chairman.
This is reimbursed deed. And this is in compliance with the law. Why did you do this? So those ones who have not complied shouldn't be on record. Why did you do it at your colleagues? Or why didn't you advise your colleagues also to do the same?
Who are not on this list shouldn't even be here? I don't know the prayer he's making.
No, they shouldn't be on the record. Yes, they shouldn't be on the record. I think you have not appreciated the regulation. It is not my law. Read it.
I think I want to recreate the position of the Honorable Ronde Mayor that my colleague in uniform is on a mission to mislead this Honorable Court, and he's doing well in that direction. If we had taken the time to read Article 28 of the Constitution, which I'm going to read for him, Article 28, 1 guarantees the right to a fair hearing. and guarantees a right to a lawyer of his choice and defense facilities. Article 44, paragraph C of the same constitution says that this right is not negotiable in my language, but in its speculation it uses English of non-derogable. Notwithstanding anything in this constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. Paragraph C is the right to a fair hearing. The right to a fair hearing includes the two accused persons choosing their lawyer, which they have done. You can't tell them, even now they can appoint a lawyer. Now as we proceeding, they can even fire us and replace us. That's fair hearing. That rule you are quoting is null and void. Article 2 of the Constitution is very clear that if any regulation, rule, speech from the Prosecution is inconsistent with the Constitution, the words of the Constitution, Chairman and members of this court, is such a things as he is saying are null and void. That is Article 2 of the Constitution. Will this court follow null and void submissions, or will it follow the provisions of this Constitution? Thank you very much. For 5 years, studied this law, and this Constitution was promulgated in 1995, and Article 221, these articles are in my head, says that UPDF shall promote, respect, and protect this Constitution and the fundamental human rights of Ugandans. And we are saying the right to a fair hearing is not negotiable. And we are saying the right of Besigye and Millitary to choose their lawyers, even to change them, is not negotiable. So if you have not read those specific provisions, you shouldn't come here to mislead the court.
You should come when you are prepared.
I am prepared, that's why I'm reading the Constitution and you are reading the rhetoric.
Mr. Chairman, if I may, and I know I am perhaps one of the subjects of the objection, but if the court will allow me to just address it. I think my learned friends have made very clear what the Constitution says. The right to appoint counsel is a prerogative of the accused. What the state is citing is an administrative process of notification, so that we tick boxes, we dot the I's, we cross the T's. But that is a technicality, no completely ignoring it, but it's undue. And perhaps there are practical ways of dealing with that administrative problem that the court has been made aware of. The accused are here. They haven't yet spoken and said that the list of people that was read here is a list of masqueraders. I believe they can confirm, if they are required to do so, that the list as read are their lawyers, so that we move on to something else.